Hello, everybody. My name is Joel Lawrence. I'm the policy monitor with the Texas Indigent Defense Commission. And what I do, as well as some other staff, is we go to jurisdictions and we look at their practices, and we try to compare those to the requirements of the Fair Defense Act. A lot of these requirements are timeline-based, and it follows this flow chart as you see there. We look at things other than these time frames, but this acts very much like a track relay. And in a track relay, you have runners that run around the track really fast and they hand off a baton between each other. But if they don't plan everything out and communicate, they're probably going to drop the baton, even though all they're doing is just running. It might be a very simple operation, but unless everyone talks to each other, bad things are going to happen. And the same thing happens with indigent defense. So I want to talk about a few of the issues that we see. And the first thing that has to happen is a person is supposed to be brought before a magistrate within 48 hours of arrest. For misdemeanor cases, there has to be a probable cause hearing within 24 hours. And this hearing is called magistration by some people. Some people will call it the Article 15-17 hearing. Some people will call it magistrate's warnings. But at this hearing, among other things, the magistrate's supposed to find probable cause, or find if there's probable cause, a little bit of a difference, to detain the individual. They're supposed to set bail, and it's supposed to ask and record whether the arrestee wants to request counsel. Across the state, I think most jurisdictions are very good about having timely warnings, but sometimes there's issue with the ability of arrestees to request counsel. And what I mean is sometimes you'll see a jurisdiction where the request for counsel has been taken off the magistrate warning form. Sometimes you'll have a hearing where the judge will speak really fast and a bunch of drunk defendants really don't know that this is the time to request counsel or even that they have a right to request counsel. And as a third example, I was in a jurisdiction a couple years ago where it was very early in the morning, and the magistrate, he found probable cause and set bail for everyone, and then he had everyone stand in line, and they came up and signed the form. Well, on that form, if everyone had bothered to stop and read it carefully while people were behind them waiting to sign it, it says, do you want to request counsel, yes or no? Well, no one read the entire form, so they just signed their name and moved on. So after the hearing, I spoke to the judge, and I said, Judge, there is a little problem here. You have to ask each person whether they want to request counsel. And he was agreeable to that. And so afterwards, I went to McDonald's because it was very early in the morning and the courthouse still hadn't opened. Well, as I was waiting in line at McDonald's, I got a phone call, and the judge started thinking about this, and he told me I was taken a little bit aback, and he said, isn't there some way around this? If you let people request counsel, everyone's going to do it. And I think that's the real issue is this is a constitutional right that you have to let them try to exercise this. As a judge, you can't put roadblocks or try to hide the ball. And in a few instances, we do see instances where judges are hiding the ball or they're putting roadblocks. I think overall, judges are very good about making sure that defendants know this is the time to request counsel. If you want to do this, you need to ask for a form, and I'll give it to you. But request rates do vary across the state, but I think overall judges are very good about making sure defendants know their rights. Where there really are problems are in the next phase. What if an arrestee wants to request counsel? What do you do? Well, Article 15-17 requires that the magistrate ensure reasonable assistance in completing the necessary paperwork. It also requires that magistrates ensure that this information is transmitted to the appointing authority within 24 hours. However, the statute doesn't require that the judges do this themselves. And in fact, most judges are very busy. They don't have time to do this themselves, or otherwise they would spend all day doing it. And so what typically happens is the judge will hand over a piece of paper, an affidavit of indigence for the arrestee to fill out. And the arrestee, it's up to that arrestee to get it completed and somehow get to the courts. And in a lot of places, the courts will lose half of their requests or more because they just never get these forms back from the arrestee. Or maybe they get them back and it gets into a jail outbox and the judge will get it 2 weeks later. But this is a real problem because as the courts go, How do you know how to rule on a request you never see? So large counties, that is, those counties with more than 250,000 people, they have 1 working day to rule on this request, and smaller counties have 3 working days. But the real problem is judges are usually rule upon the request as soon as they get it. They just don't get the request, or they get it after it's due. One other issue we sometimes see here is, in the past, judges used to be more scared to deny indigence if they didn't believe the person was indigent. A really bad practice is to, if you don't believe the person is indigent, just to let this go pending, because it can have some later problems. And then finally, one thing that can really help a judge is if the magistrate warning form is in the case file. Most clerks don't keep the magistrate warning form in the case file because it occurs before the case is filed. But as a judge, you may want to know, did this person request counsel at the hearing? Because if you don't have that form, the only way you're probably going to know is if you got the paperwork from the arrestee, and you may only get half of those. And so we recommend, as a best practice, that that form get in the case file. And finally, as another issue that we often see is, if you want to appoint counsel in an evenly distributed manner, you have to have a plan to follow a wheel. If you just wait to see who's in the courtroom, the odds are those appointments are all going to go to a couple different people. And then you're going to have what we consider not to be a fair, neutral, and non-discriminatory appointment system. So I told you a couple issues that we see, but there are a few solutions. And one practice that I think is very good is, if someone requests counsel at the magistrate warning hearing, that person does not go back to his or her cell until all the paperwork is completed. Now jails have a very tight time schedule, and this can't always occur. And so if that doesn't happen, there needs to be a master list where you document every person that went before the magistrate and whether they requested counsel. And then there has to be some kind of follow-up to see, do I need to collect these forms? Otherwise, you're going to lose a lot of requests. And finally, one thing that we like to fund is pretrial services / offices and indigent defense coordinators. They can be very useful here. They can interview arrestees. You get a little bit better quality information on the affidavit of indigence. They're very good about collecting these forms, and they can follow a wheel when an appointment needs to be made. And now I want to switch gears a little bit, not talk about time frames so much, but I want to talk about waivers of counsel. This is a problem we see in a lot of places. In small counties, I often hear, well, you know, everyone knows everyone in this community. If someone gets in trouble, what they want to do is they want to talk to the prosecutor and resolve the case as fast as possible. And I agree that this is true, but there's one part of this that's missing, and that is that a lot of these people would like the assistance of counsel in working out this deal. And what the courts and the prosecutor often don't know is that person that's coming to them, there's a very good chance that they actually did request counsel. They just don't know it. And so if someone wants to come to court either at the initial misdemeanor docket appearance, or they just come to court outside of a docket and they want to talk to the prosecutor, there's a few things that have to happen. First, the court has to advise the defendant of the right to counsel and the procedures for requesting counsel. Then the court has to rule on all the requests, and then the defendant can waive the right to retain counsel. At that point, the defendant can talk to the prosecutor. The prosecutor can't communicate with the defendant who has requested counsel unless the court has determined that the person is not indigent, and the defendant has either waived the right to retain counsel or has been given a reasonable opportunity to retain counsel. At that point, the defendant can speak with the prosecutor. And the real kicker here is that any later waiver of counsel for a plea, it's presumed invalid under Article 1.051F if those conditions have not been met. So here's the problem. As a court, you're only getting a portion of the requests that are coming in. And yet you have to deny all the requests before this person can speak with the prosecutor. So then what do you do about these uncounseled pleas? How can you be confident that they're valid? And so my big message is there needs to be a process to gather all the requests for counsel and rule on them. And that's going to take a lot of coordination, because otherwise you're not going to get all the requests, and you can't rule on them if you don't get the requests. And then you may have some invalid waivers. I didn't say are invalid, I said presumed invalid. But as a judge, you'd probably want to make sure that they are valid rather than there's some kind of presumption against you. As the commission, we have some model forms. One of them is a model waiver of counsel to speak with the prosecutor. And the reason I like this form is it tells the defendant the options that are available. You can represent yourself, you can try to hire counsel, you can request counsel, but you have to pick one. And what this does is this explains the procedures for requesting counsel. It notifies the defendant of the right to counsel, and it forces the defendant to pick a choice. So then you can clearly say, hey, we've met this part of the statute. It doesn't say that you've ruled on all the requests, but it talks about the rest of the statute. Now, once a defendant has talked to the prosecutor and come to a plea agreement, the next thing that has to happen before this plea can be accepted is the judge has to determine that the waiver is knowingly and voluntarily and intelligently made. And once the judge does that, there can be a waiver, but it has to substantially conform to the words of Article 1.051G, and those are in italics there. You don't need to read it there. I just want to make clear that a lot of counties, they kind of freestyle on this language. And I don't judge whether the language of a county's waiver substantially conforms to 1.051G, but if that's the standard you go by, it just doesn't make any sense to me why you'd want to deviate from that language. So I just highly recommend that you look at your own waiver of counsel for unrepresented defendants and make sure that it follows this language. I mean, the format can be different. I mean, there's a better format than that, clearly. But sometimes you just see odd terms thrown in, and why would you want to try those odd terms if this is a requirement of statute? And with that said, I just want to list on our website, we have some resources. One is a link for our model forms and procedures, and also a link from a primer for local officials. This talks about our agency, and it talks about some statutory requirements. And so with that said, do we have any questions, or do we have any time? No time. I guess we have no questions then.